Assalamu alaikum. You're watching Just Law. As you know, in this program we discuss legal matters. We invite guests to assist us on those matters. You can ask your questions today in English, in Bengali, and in Urdu, inshallah, or perhaps in Arabic. Let me introduce my guest who's going to assist us with your questions today. I have Arnab Sen, who is an immigration consultant working in central London. He has an office in Edgware Road. So inshallah, we know immigration is a very popular topic. So inshallah, you'll have a lot of questions to ask him. By way of starting, inshallah, I'll ask a few questions to him about updates and things that have changed recently, which the viewers may not be aware of. So Arnab, tell me, has there been some recent changes in the last 2-3 months?
Yes, this month, August, is a month of changes for Tier 4. And unfortunately, there are some news which are not very pleasant for Tier 4 students in this country. Number one, of course, the Tier 4 students who studies in colleges. The Tier 4 colleges which are publicly funded, of course, the students cannot work. Those who are studying in publicly funded
So they were
Tier 4
previously
colleges.
allowed to work? Now
They were previously allowed to work, but private colleges were already banned, and they are bringing in line with the private colleges. The public funded colleges are also banned. The students under Tier 4 visas or studying in the publicly funded colleges are banned to work.
So this was 20 hours before, now it's zero.
It's completely zero, yes, for publicly funded. By saying that, I can assure that the students who are in higher education institutions, not colleges, but the universities are still allowed to work as per the 20 hours term time and unlimited full-time work in the holiday period.
Is there a further restriction as to the type of work they can take? Or?
Not for students, but for Tier 4 dependents. The dependents, I think this rule is coming in November. The dependent visa holders coming to join their Tier 4 husband or wife can't take any unskilled work. They can only do part-time and full-time skilled work. But how they will determine what is skilled work and what is unskilled work is still not clear in the website. But this is an announcement we found from the ministry.
Okay. What about we know that they stopped PSW going back a couple of years. So if you were a student and then you went to post-study work, that stopped. Has there been new developments as to other things that's been discontinued? For example, can you still do like an entrepreneur application on the previous basis, or has there been changes to that?
I guess, your question is towards Tier 1 post-study worker. Can they switch to Tier 1 entrepreneur visa? The question is, yes, they can switch to Tier 1 entrepreneur visa, but the funding has to come from approved sources, either government funding or UKTI funding. These are the particular categories of funding which are only allowed. But for particularly Tier 1, that is of course for the Tier 4 students. I'm talking about, your question is about Tier 1 post-study workers. They can switch to Tier 1 entrepreneur visa also if they have own funding, but that they have to prove that they have already established their business in the United Kingdom, and they have sufficient proof of that. Prior to 11th of July 2014, their business was operative in the United Kingdom.
So this would apply to people who had already established businesses
yes.
Last year effectively?
Yes, and they are relying on their own private funding, not from government funding or UKTI
not third
funding.
Parties?
Yes.
Okay, viewers, you can participate with us, you can join in, you can call in inshallah. You can also email us, justlaw@iqra.tv. Of course, we do want to hear from you. And inshallah, if you do call in, you don't have to give us your name if you don't want to. Set us your facts or what has happened, or if you have intention of bringing somebody over from abroad and you're unsure as to what the recent requirements are or the updates are, or if you're planning for the future, if you're thinking post-November or next year someone's going to come over, the new rules will take effect, and that may actually change plans, or you may have to do things differently. On top of that, inshallah, as you know, the emphasis now really is shifting. Before, the immigration rules were accommodating to students, making life easier, allowing them to work. It was more sort of reasonable. Now it's sort of being tightened further. So it's imperative that you seek advice before you plan, because if your plans don't incorporate the changes, then you may find a nasty surprise. So inshallah, do your homework, make sure everything is in place. You can write to us, you can call into our show and ask your questions. You can ask us in your native language. So if you speak Bengali, if you speak Urdu, if you speak Arabic even, inshallah, you can ask. So I don't know, you speak Bengali, you speak Urdu, you speak English.
Yes, I can be comfortable to speak in Bengali, Urdu and Hindi as well. Arabic, I have to leave it to you.
Inshallah, if there is any Arabic questions, I will deal with that. But আমাদের অতিথি আজকে বাংলায় কথা বলতে পারেন. You can say something in Urdu, inshallah.
Of course, आप हमें इस नंबर पे फ़ोन करें और आपके जो इमिग्रेशन रिलेटेड प्रॉब्लम्स है वो हमसे शेयर करें. और हमारे पास अगर आंसर हो उसके लिए तो हम अभी आपको एक आंसर दे सकते हैं. अगर नहीं हो तो आपको हम लोग बोलते हैं कि कोई आपके लोकली कोई सोलिसिटर से आप कांटेक्ट करें इसके लिए, और आप हमें लिख सकते हैं जो कि आपको स्क्रीन में आएगा. एक ईमेल के ज़रिए आप हमें आपका प्रॉब्लम लिख सकते हैं और हम आंसर आपको ईमेल कर देंगे. The thing is, Saleh, the another important factor we should bring into the picture here, that tier 2, those tier 4 who was here in the United Kingdom and could conveniently switch to tier 2.
So you're talking about students who finished their studies, now they want to be sponsored as an employee of some sort.
Exactly.
Has that stopped?
That has not stopped until now, but they have stopped even college students. It seems that the colleges are finding it very difficult under the present regime or present immigration rules, because the tier 4 students who are studying in college cannot switch to tier 2 or tier 5. They have to go back to their country.
So they have to make out-country application.
Of course, yes.
That will mean if they're hoping for the 10-year indefinite, that
would stop
introduce difficulties.
That would stop there, because the clock will stop once you are out without any visa. And any long residence route out of this 10 years rules we are talking about has to stop there.
What happens if they left before their visa expired, reapplied and came back? Would that not work, or it would be tricky still?
It would be still tricky application. It also, there is a fair amount of discretion applies, but once you are out and your visa is no more there, even if you have applied after that time, your clock
there is a gap.
Stopped.
There is a gap, and so the 10-year rule would be problematic. And we don't know what will happen in 10 years, so they may have changed.
They might come back with some other harsher rules to stop even 10 years. We don't know, so it's not good to advise in speculation.
Okay, you were talking about progression. So what happens if someone comes and studies, they're on a 2-year course, and for whatever reason they've not progressed? Would there be an automatic stop to extension, or can they still extend?
Very rightly said so, because recently they have introduced a law that tier 4 students have to show the progress in their studies, and they can't choose a new course without any sufficient link to their previous course, or their university has to affirm. And this is the first time, this is a new rule I've seen in the announcement, that they are involving their universities to affirm that this particular new course
is a continuation from the previous one.
Of the career aspiration of the particular student. And if the university is somehow not careful in such affirmation, they can be also interviewed, and their licenses can be coming to some question mark. So this is a new thing, even it's coming in from this month for the new rule. I
was under the impression that UK universities, UK colleges They make a lot of money from students coming from overseas and paying overseas fees.
Yes.
But the Home Office rule changes seems to be tightening that. Are they not interested in foreign students coming and studying here, or are they worried too many are staying? What's the
of course?
What's the logic behind all these difficulties? Because someone might come here,
yes.
They may study accountancy and they may not like it, or they may, legitimately want to switch to a different career path or do something different.
The bottom line is, if you can come here on a student visa, then you can again come here on a student visa. They do not want you to use it as a ploy to get your 10 years long residence route to get settlement in this country. That is, I think, the bottom line here.
So the focus is to stop people reaching that goal of becoming resident in the UK.
To stop people or the crowd to become a settled person in this country. They are saying, well enough, you want to study another course, you can go back to your country and you can reapply. But I'm saying again, this is only for the college students, tier 4 colleges I'm talking about. But they are linear about students who are in the country. They can still extend their visa, but the college has to be in an embedded college link. That means that college having some sort of connection with universities which are recognized by the Home Office. So they are kind of sorting the educational institutions and selecting educational institutions and more keen to provide access to university students rather than college students. If the college students can come to study, but they have to probably go back and then again reapply if they want to study or stay here.
Okay, so essentially they're making it a university thing or a college that is connected directly or indirectly to a university.
Yes.
So that's following the progression theme, I would have thought.
Not only the university, mind my word, that university has to be recognized by Home Office. So they are selecting a particular group of universities.
I think going back some years, there was one university, we won't name, where they had their license revoked for not keeping the paperwork in order. So it's quite possible, even if it's a university, if not everything is ordered, the applicant or the student could actually find themselves in difficulties.
That's very much so, because, and there you are, the university, even in fact the educational institutions nowadays need immigration lawyers to keep their documents right, to be protected for any kind of audits that may happen anytime unannounced. And I think this is a high time they should consult their immigration consultants or solicitors to keep their documentation properly, so that they do not fall into a wrong foot in any kind of visits from Home Office staffs.
Okay, so they need to keep their documents in order, make sure all the requirements are complied with.
Yes, especially the sponsorship.
Because there is a real risk that if there is an audit, that their license may be revoked.
Of course.
Have you come across situations where the university is extra harsh on the student because they want to preserve their highly trusted status? I had one case where the university was unsure where an applicant would succeed or not. So they refused to grant a CAS. Because they're saying we have a certain number of refusals, and by granting the CAS, that increases the number, which means we may lose the highly trusted status.
They are very much careful nowadays, and some people are over careful, over cautious. Some universities, I would say, I don't want to take any name, but a very reputable university actually was refusing on the ground of English language requirement, whereas that particular student have passed a graduation degree from them. So I had to write letter to convince them that the university degree has a permanent effect on the English language requirement. If somebody has done an English UK graduate degree.
Did you need to provide a NARIC sort of equivalence, or? No, I mean there isn't one because it's
because NARIC normally require, if you have done
foreign
a degree
certificate
from foreign institutions and you have done it in English, then NARIC confirms that the level of English or the level of study they have gone through is basically at par with the UK graduate qualification. But when you have a UK graduate qualification itself,
there's no need for that. They should have accepted.
Is sufficient for anybody to satisfy.
Okay, I'm going to turn to the viewers, inshallah. Assalamu alaikum. Let's take the next caller. What's your name? Where are you calling from? Hello, caller.
Hello.
Yes, you're live. Tell us, what's your question, please?
Hello.
Can you hear us?
Hello.
Yes, ma'am.
अस्सलाम वालेकुम.
वालेकुम सलाम.
मैं आपसे एक अपने बेटे के मुतालिक क्वेश्चन पूछना चाहती हूँ. मैं यूके में रहती हूँ और मेरा बेटा है वो पाकिस्तान में है और मैंने उसके लिए सेटलमेंट का वीज़ा अप्लाई किया था तो इन्होंने उसको रिजेक्ट कर दिया. इवन के मेरे 2 बच्चे मेरे साथ हैं और उनके पास भी ब्रिटिश पासपोर्ट है और मेरे पास भी है, लेकिन वो अपने डैड के साथ रहता है. तो उन्होंने जब मैंने अप्लाई किया तो 16 ईयर का था और अब इन्होंने उसको अपील में भेजा तो लेकिन उन्होंने रिजेक्ट कर दिया. अब मुझे समझ नहीं आ रही कि मैं उसका कौन सा वीज़ा अप्लाई करूं. मैं दोबारा उसको अप्लाई कर सकती हूं या मैं उसका विजिट वीज़ा अप्लाई करूं. उसके फादर ने पहले उसका एक वीज़ा अप्लाई किया था इंग्लैंड के लिए तो उन्होंने मुझे मेंशन नहीं किया था. आई डोंट नो व्हाई ही डोंट वांट टू मेंशन मी. तो उसने मेंशन नहीं किया था. उसके बाद मैंने उसका सेटलमेंट का वीज़ा अप्लाई किया क्योंकि वो अलाउन रहता है वहाँ अपने डैड के साथ तो वो उसकी सही तरह से लुक आफ्टर नहीं हो रही, वो ठीक भी नहीं है तो इस वजह से. लेकिन इन्होंने रिजेक्ट कर दिया. अब वो 18 का हो गया हुआ है तो आज मुझे समझ नहीं आ रही कि मैं उसका विजिट वीज़ा अप्लाई करूं कि मैं उसका दोबारा से सेटलमेंट अप्लाई करूं. तो उसका क्या होगा, उसको दोबारा अप्लाई कर सकती हूँ कि नहीं?
Okay, thank you for your question. I'm just going to translate for the viewers who don't speak Urdu. The sister's called in. She has 2 children in the UK. She has a child in Pakistan who lives with the father. The child had applied for a visitor's visa to the UK, but didn't previously mention the mother. So that caused a bit of problem. And then they applied for settlement for the child to come live with the mother. And this settlement application has been rejected because there is a father in Pakistan. What can we do in this situation? Because I think visitors' visas now is going to be tough. Because you've got 2 rejections, as far as I understand.
But I mean,
and there's been a settlement application. And yes, usually if you apply for settlement and then you apply for visitors, you know, they will say you have intention to remain, so visitors would not be appropriate.
I try to explain in Urdu because the caller has...
Okay, fine. And then we'll give something in English as well for the rest of the viewers.
Problem ये है कि visit अभी the child था वो 18 years हो चुका है और
I heard 16, no?
No, अभी 18 हो 15 the first applied and अभी शायद 18 हो गया. अगर 18 ना हुआ हो तो अभी भी वो settlement के लिए apply कर सकता है as a child to a mother who I suppose is a British or settled person in this country. So by meaning settled is indefinite leave holder. पर इसमें 2 तरह के प्रॉब्लम आ सकता है. एक तो है कि आपके हस्बैंड का भी एक रोल इधर रहता है और आप अगर बेटे को उधर से लाना चाहते हैं तो आपको ये प्रूफ करना भी ज़रूरी है कि उसका सोल कस्टडी आपके ऊपर जाता है और इसके लिए आपको कोर्ट से एक्सेशन ऑर्डर लेना पड़ता है जो कि आपके पाकिस्तान कोर्ट से ले सकते हैं आप और या आपके उसके फादर को ये ऐसे कुछ डिक्लेयर करना चाहिए कि जो आपके पास रहने से ही उसका अच्छा परवरिश होगा. तो ये एक चीज़ इशू आता है जो मैटर है उसको देखना चाहिए. और मेरे ख्याल से अगर 18 हो गया हो तो विज़िट वीज़ा अप्लाई होना चाहिए इसमें. पर विज़िट वीज़ा में ये प्रॉब्लम आ सकता है कि उसका एप्लीकेशन रिफ्यूज़ भी हो सकता है और रिफ्यूज़ होने के बाद उसका कोई अपील राइट तो है अभी है नहीं, वो दोबारा एप्लीकेशन ही जाता है. पर अगर आपको ये लग रहा है कि वो आपको अनजस्टिफाइडली रिफ्यूज़ करते जा रहे हो कि विज़िट करने के लिए वो लोग मंजूर नहीं कर रहे हैं तो आप उसको जुडिशियल रिव्यू में पे भी
और
ला सकते हैं
एडमिनिस्ट्रेटिव रिव्यू
और एडमिनिस्ट्रेटिव रिव्यू पे भी ला सकते हैं इसको। एडमिनिस्ट्रेटिव रिव्यू नॉर्मली जुडिशियल रिव्यू के पहले आता है, जो कि वो उन लोग इंटरनल डिपार्टमेंट उसको चेक करता है, और उसके बाद अगर वो सेटिस्फाई ना निकला तो आप 3 महीने के अंदर अंदर डिसीजन निकलने के बाद जुडिशियल रिव्यू करवा सकते हैं उस डिसीजन को।
Okay, thank you very much for that, Arnab. Generally speaking, just for the rest of the viewers, where there is a family separated into two parts, say the mother lives here with a couple of children, and then the father lives abroad with, say, one of the children, and that children wants to now come over and live with the mother. Now, if they're over 18, that can happen, but the Home Office is likely to refuse if the other parent has been looking after the child, and the other parent is still there and capable of looking after, etc. The situation that needs to arise is the other parent is not able to look after that child there. The parent here is effectively sending money and making sure the day-to-day activities are conducted on their behalf. And then the child can come over and live in the UK and settle in the UK as the UK parent is the has the sole responsibility for that child. It's very tricky, it's very difficult. Particularly if other parent is there. So if the other parent has no regard for the child, is not caring for the child has been looked after by, say, the parent that's in the UK, maybe their grandparents or something, then it's possible, but I would advise that you seek advice from immigration practitioners, lawyers here, so make sure the issue is dealt with properly. I see a lot of refusals based on, oh, the other parent is there, or we don't have consent from the other parent, and things like that. So we need to make sure that it's done properly. You explain the situation, you have consent from the other parent, or the other parent is not involved at all. The child's finances, day-to-day care, etc. is being cared for by the parent that is here. And of course they have adequate finances, accommodation, etc. Just like a standard settlement application. So these things are very, very important, because the Home Office will say, you know, the other parent is there, they don't need to come over. We're going to go for a short break, inshallah. We will see you afterward. Please do remember to write to us, iqratv@justlaw.com. Of course, keep watching, invite your friends to watch. We're going to go over a break, so we'll see you on the other side. Assalamu alaikum wa rahmatullah.